going to call the House Judiciary Committee to order. Madam Clerk, will you please call for attendance?
Chair Lightner.
Here.
Representatives Bagol.
Here.
Wozniak.
Here.
Harris.
Here.
DeBoyer.
Here.
Johnson. Here. Schutte.
Here.
Carter. Hope. Here. Breen. Scott. Madam Chair, you have 8 members present. You do have a quorum.
Thank you, Madam Clerk. Rep. Schutte moves to adopt the minutes from the August 27th meeting. Hearing no objection, the minutes are adopted. Rep. Johnson moves to excuse absent members. Hearing no objection, absent members are excused. Okay, today we're going to go ahead and get rolling while we wait for some members. We had some traffic incidents. I don't know if you guys noticed out there between there and around Fowlerville. So we will try to be a little patient, but we do have people on Zoom. So I want to go ahead and jump into testimony. With that, Rep. Wortz, I'm going to call you up to discuss your bill 4596 in regards to competency and the waiting period. And with you, wishing to speak in support of the bill, Zach Stempian, sorry, from PM.
Thank you, Chair Lightner, members of the committee. House Bill 4596 is a technical fix to the mental health code that came to my attention due to a recent case in my district, where a defendant was found mentally incompetent to stand trial, but was unable to receive prompt treatment at a state facility. Here with me today is Branch County Prosecutor Zachary Stempian, who can discuss the case and the broader issue in greater detail. And I also have my Sheriff Fred Blankenship on via Zoom.
Thank you for taking the time to hear my testimony this morning regarding the bill. I think when you look at competency, it's certainly not considered an emotional issue or an issue that grabs a lot of the public attention, but it certainly under the surface is a very important issue that needs to be addressed. Competency, just to kind of help clarify for those that do not quite understand the difference between competency and criminal responsibility, competency pertains to a defendant's ability to assist in his defense and understand the criminal justice system. It is different from criminal responsibility, which is the mental state at the time of the actual offense. So competency and mental insanity are two different scenarios. In this bill, we're looking to address just the competency, which I think it's important to distinguish that competency involves the status of the defendant at the time the case is going through the court system. It's disconnected from the actual crime itself, if that makes sense. So in my time as the elected prosecutor in Branch County, I've seen many defendants who were competent to stand trial, but legally insane at the time of the offense, or vice versa. They were incompetent to stand trial, but clearly legally sane at the time of the offense. The unfortunate part of the bill at this point in time, and I certainly don't think it was the intent when the bill was drafted, is it creates an ability for a victim in a case to have their rights stripped from them and have the ability to be made whole stripped from them. And what I mean by that is, right now as written, the bill requires dismissal of a case if the defendant is not restored to competency within 15 months or 1/3 of the statutory max. So for example, if you had a 1-year misdemeanor, it would be 3 months and some days that they'd have to be restored. If they're not restored within that time frame, we have to dismiss the case. There's only certain times that a case can then be refiled. A case can be refiled if it's a case that's punishable by up to life in prison, so homicide, CSE1s, things of that nature, or if the defendant is restored to competency within 1/3 of the max after the case was dismissed. So there is a slim point that you can refile the case, but otherwise you cannot. So if you cannot refile the case, essentially the case goes away. Now the defendant would still be subject to the mental health system, but that may not be into perpetuity. It may not be, for a long time out. It could just be a relatively short stint within the mental health system. As my time as a prosecutor, I've seen defendants who have come in who were found incompetent to stand trial. The case was dismissed, only for them to be back in front of the court 3-4 months later on a new criminal offense, and again being found incompetent to stand trial, case dismissed, and we go in this circle where there's really no punishment that we're able to do because the case is always being dismissed against that individual. The 15-month fix in the bill, the fix that we're looking to do is the 15 months would now start at the time the defendant is actually admitted to the center for treatment. Right now, the 15 months starts as soon as the order finding the defendant incompetent is entered. It's also important to note that the 15 months also, if there's competency comes and goes. So defendants sometimes are competent, and then they become incompetent, and then they're competent again. The 15 months adds all that time together. So what brought this to my attention, and besides other cases, what really brought it to the forefront is I had a case that involved essentially a double attempted murder and then significant stalking. So a defendant was engaged in a course of stalking of multiple individuals. That then led to him attempting to run over 2 other individuals and attempting to kill them, and they suffered serious injury. The defendant was charged with 2 counts of attempted murder and then multiple counts of stalking. And I will just clarify, the case is still pending, so he's still presumed innocent at this point in time. But the defendant was ultimately found incompetent. He was ordered to undergo treatment at the state hospital. After the court sent the order to the state hospital, they got an email back that said, okay, we received it, he's on the list, just so you know, he will not be admitted until at least the 366th day of his incarceration. So it took 3 months for him to be found incompetent, so that was essentially 9 months after the order was entered would be when he would start treatment. So that would leave us then 6 months to restore him, or we'd have to dismiss the case. The other interesting thing in the law is when you read it, if the case is dismissed against the defendant because of that 15-month time period, it can be refiled for a capital case such as attempted murder, but the defendant cannot be held in custody or institutionalized while that process is going through. So essentially, I'd have to petition the court for approval to refile the charge. The defendant would be at liberty at that point in time on very significant charges with them pending until the court approved that. So certainly that creates some significant concerns for victims, and I think the best way that I can explain it is it's very difficult as a prosecutor to sit down with a family and look at them and go, I understand that what this defendant did to you was horrible. I understand that he changed your life for the rest of your life. But unfortunately, because of his mental status at this point in time, I'm not sure if we're going to be able to prosecute him. And again, I say that it's a distinction between criminal responsibility, which I think we all accept is fair when somebody's legally insane at the time of the offense, compared to somebody who has a mental breakdown during the pendency of the case. When you sit down and talk with family members about that specific issue, they're often left feeling like they're not being made whole, like their concerns are not being met. They're left feeling unsafe, that they're not going to be able to be protected. And the reality of that is some of that is true. If a case is dismissed against an individual because they met that 15-month time frame, no felony conviction would enter, which means there'd be no preclusion on having a gun in their possession down the road. Certainly there could be some preclusions for CPLs, but nothing for shotguns, rifles, or any other weapon. There would be no felony conviction. If it was a CSC offense, there'd be no SORA registration. If there was restitution owed, so let's say they damaged somebody's property or medical expenses in my case, there would be no restitution ordered. So a victim would be left with really no remedy whatsoever because the status of the defendant during the trial process was not where it needed to be. The 15-month would just extend that, would give the center the ability to have more time to treat these individuals. And I think at the end of the day, we all want competent individuals in the court system. This isn't a way to say that that's not what we're trying to address. It's just the reality of it is, as we all know, the center is at times overburdened. The center has a long wait list. I think last time I looked, it was over 200 beds. 200 people were waiting to get a bed at the center. So this would help alleviate some of that stress on the center. At the end of the day, when you speak with victims, attempted murder seems obvious, right? Like, yes, that case can be refiled, so what's the issue? Well, before I came today, I looked up a whole bunch of crimes that could not be refiled if the law was not changed. So the second change that this law does is it allows the court or the prosecutors to refile any felony case with the approval of the judge. So again, you would petition the judge, he would approve it, you could refile any felony case. A list of felony cases that under the current law could not be refiled if the defendant was not restored to competency within 15 months and you fell outside the time frames would be resisting and obstructing a police officer resulting in death, leaving a child in a vehicle resulting in death, creating child pornography, possessing it, distributing it, anything involving child pornography. None of those are life offenses. CSCs 2, 3, and 4, cyberbullying causing death, throwing objects at a car off of like a bridge or something causing death. First-degree vulnerable adult abuse, so serious harm to a vulnerable adult. Assault with intent to maim. Assault by strangulation. Second-degree arson, which is a burning of a dwelling. And in my time, I've actually had multiple of those cases with individuals that had mental health issues going on. Dangerous animal causing death. Killing or torturing an animal, which I think we all know oftentimes leads into other significant crimes. Home invasion first degree, which is assault with somebody inside the home. All breaking and entering crimes. child abuse in the second degree, which is causing serious physical harm by a cruel act to a child, assault with intent to penetrate, manslaughter, all OWIs causing death, reckless driving causing death, marine crimes causing death, abortion causing death to the mother, manslaughter with a motor vehicle, killing of an unborn child, which again is different than abortion, all domestic violence crimes, all stalking crimes, misrepresentation of medical treatment for sexual contact, which I think is a relatively new law based upon conduct in the state, misrepresentation of medical treatment for penetration. Again, all these crimes would not be able to be refiled if the law is not changed to allow all felony offenses to be refiled at any point in time. So with that being said, what I'm asking this committee to consider is the bill that to some degree restores a sense of security to victims. That way, when we have these conversations with victims, we do not have to say, well, there's nothing we can do if he does not regain competency. It's, yes, we can still pursue this down the road when we need to. I'd be happy to answer any questions anybody may have.
Thank you, prosecutor. I just have one right now. It's in regards to the forensic center. What's your average wait time for an evaluation to actually happen or occur?
Yeah, so it varies. If it's a misdemeanor crime, because there are some misdemeanor crimes that get sent for restoration of competency, they tend to get those in quicker because the time frame is shorter, right? So if you have a 93-day misdemeanor, domestic violence, for example, they only have 30 days from the date of that order to restore that person to competency. So interestingly enough, they can usually get that person in, which was part of my frustration on the case that I have right now. Is I had somebody charged with attempted murder that was not getting in, and then individuals that were charged with misdemeanors that were getting in. This individual sat in our jail after the order for over 9 months. They have to do a reevaluation of competency every 60 days. And one of the reevaluations, they ended up finding that he was competent. At that point in time, his mental status has improved. So he actually never ended up going to the state hospital to get treatment. Now the case is ongoing again. But usually it's somewhere from 6 to 9 months. I've had individuals sit for over a year. So it's somewhere between that time frame, 6 to a year.
Rep. Wozniak.
Thank you, Madam Chair. Going through this, is there any particular reason that they couldn't use private services rather than just a state hospital to have treatment?
The statute could allow that. The court has to appoint somebody to be in care of the defendant's psychiatric care. So I suppose if there was a facility that would meet the requirements of that, they could do that. Competency restoration is, I think certainly any psychiatrist could do the services for that, but it's also a little bit more specialized than just general mental health issues. So, somebody could certainly be bipolar, but then be competent. There's a different treatment for that. But I think certainly private services could handle that if the appropriate services were put into place. And then also lockdown facility versus not lockdown facilities would be another consideration.
I was just thinking the time issue, sometimes it'd be better to outpatient it.
Yeah.
Can I add to that? On a personal note, I had a family member who needed a psychiatrist, and it was at least 90 days to get into a psychiatrist as well. Mm-hmm. So there's a shortage of those, even in the private sector.
Yeah. Thank you.
Rep. Breen.
Thank you, Madam Chair. I apologize if I missed this information. I'm worried about the feasibility of implementation. And I'm wondering if you have a general idea as to how many cases this could possibly affect. And have you spoken to any judges about the impact? I'm especially concerned because I know that the Attorney General handles prosecutions in some counties. With this uncertain budget forecast, she's not going to be in a position, her department won't be in a position to handle those. So I'd just like to know about the number of cases and whether or not you think that will be feasible for a current court system to handle and judges' input.
So when you say the number of cases, do you mean the number of cases that would be refiled then?
Yes.
Okay. I think some of it, there's some discretion within the system. And, prosecutors, if you have an R&O of some sort, we're not always out just to get a conviction. I know sometimes that seems to be the public perception, but it's not. If you have somebody, a very common case in Branch County is there's an involuntary commitment order for an individual. The police officers go to arrest him. He resists arrest because it's an involuntary commitment order. He doesn't want to go to treatment. They submit for R&Os. We typically charge those on the front end just to make sure that we have oversight, but then they're dismissed on the back end. So there would still be discretion within the system of prosecutors saying, well, in this case, the victim is okay with the resolution. They don't want to pursue prosecution. In this case, it was extremely significant. For the public safety risk, we do have to pursue prosecution. In my time, cases that I've had dismissed with a 15-month time frame, and I've been the elected prosecutor for about 5 years now, has been, I think, 2 or 3 I've had dismissed for the time frame. The rest of them, they do tend to get them towards the back end of it and then get them in. And that's probably a discussion for a different day of how things change and what they do at the back end of that. But I don't think it would be overly burdensome on the criminal justice system, because you have those fail-safes of prosecutor discretion, and then you have judge discretion as well, for a judge to come in and say, hey, you know, I understand, but this isn't significant enough for us to put this case back into the system. The person is stabilized, they're doing well, this is really more of a mental health issue. Yes, so I've talked to my own judges about this, the Branch County District Court judge and Circuit Court judge, and they certainly, to me, and I don't want to speak for them, but would approve this sort of a time frame, because they had the same concerns that I had in this case specifically. And when they got the email, they were constantly calling like, can we get this done? We need to do more. Like, this isn't acceptable. So I do think that they would have the same concerns. The bond set in this case, the one that I spoke about, is at $11 million. That's how concerned our district court judge was. So I think he would certainly support the fact of this case coming back into the system if it was one that had to be dismissed.
Thank you. And I just want to add to that tidbit before we move on to your next person that's on Zoom. I did have some discussions with a few judges in a few different counties, actually, just this week in regards to this case, because I said, you know, what's the deal? Is this really a thing? You know, I know the forensic center is an issue. And so, you know, my argument kind of was like, oh, well, let's get at the forensic center. Like, what's going on there? Why aren't we expanding? Why aren't we, you know, forcing them to get stuff done sooner? Because, you know, the other thing with me is I was like, well, what about the right to a speedy trial? Because then you add this 15 months on top of a year they've already sat in jail. You know, it's a problem. But anyways, so they were all very, very supportive and, you know, giving me some ins and outs, more details than I cared to actually learn, but it was good information. So thank you for that. Thank you for bringing it forward. But we have your next, we have Sheriff Fred Blankenship, who wishes to speak and supports the bill, who is on Zoom. Sheriff, the floor is yours.
Hi, good morning. How are you?
Great, thank you.
Yeah, I was just came to show my support for this bill, and Representative Wortz, I thank her for bringing it to the floor, and hopefully it'll get through committee. Mr. Zach Stempian, our prosecutor, he spoke very eloquently about the issues that we have here in our county. I've been in office as sheriff for about 9 months now, but more importantly, I was the jail administrator here at the Branch County Jail for over 20 years before seeking office and getting elected as sheriff. So I know the ins and outs of the issues with mental health in jails and the forensic center specifically. We have many inmates that have waited for beds for the forensic center for up to over a year in order to get treatment. You know, why victims are waiting for justice. We have inmates that actually need help that aren't getting the help that they need. The mental health system in Michigan is not doing too well right now. The jails have become the de facto mental health hospitals in Michigan. In this case, it was a serious offense. We knew that time was going to run out before the forensic center could get them, because they did say it was going to be over a year before this guy got any treatment that he needed. And I'm just here to support the bill. If you have any questions about the forensic center, anything that mental health wise that the jails have to deal with, I'd be glad to answer those for you today.
Thank you. Okay. Well, seeing no more questions at this time, thank you for your testimony, and thank you for bringing this bill forward.
Thank you.
Thank you.
All right. Next up, we are going to hear testimony on my bill, House Bill 4525, in regards to electronic monitoring devices, otherwise known as tethers, for persons charged with aggravated domestic violence. You know, I brought this bill forward as part of our Safe Cities, Safe Communities platform. And basically what this bill does is anyone that gets arrested for aggravated domestic violence would have to be put on a tether, GPS tether, so we can monitor their movement. And this, hopefully can help deter any further aggravated assault or stalking or any of that when someone is arrested for domestic violence, because this would be a condition of their bond and release from jail. And just so you know, this is just the first hearing on this. We have already kind of behind the scenes have been working on some additional details in regards to this on particulars with the court system, with indigency, some more strict language in regards to victims, and things of that nature. But with me today, I have Dave Shepagrill, who is, he works for Judicial Services Group and numerous other groups. He's a national leader in GPS tethering, monitoring, things of that nature, not just in Michigan, but all around the country. But he does wish to speak and supports the bill, House Bill 4525. With that, Dave, you have the floor, and thank you for being here today. And if you want to just kind of give your little intro and your bio and then jump into, the tethering, that would be great.
Morning. Thank you, Sarah. Can you all hear me good?
Yes.
Again, my name is Dave Shepagrill. Appreciate you all taking the time to actually learn a little bit about these tethers. And, I interchange the word tether and ankle monitor because I think it's a Michigan thing. They pretty much only call it tethers in Michigan. But so if you hear me say ankle monitor, it's the same thing. But it's great to know that you're taking the time to do a little bit of research before just simply passing a bill. I work across the United States, and some of the bills that have been passed have made things worse for not only the court systems, but the service providers. And a little bit of background, I have been in 40 years of law enforcement. I ran an ankle monitoring program. As Sarah said, I'm currently a vice president of business development with JSG Monitoring. It's a Jackson-based ankle monitoring company. But I'm also still a senior vice president with Sentinel Offender Services. I'm their custodian of records, and I handle all of their high-profile court cases. So I go around the country and testify as an expert witness about the technology and location data, and mostly murder cases. I've served several years as the lead practitioner for the Department of Justice when we were developing the actual national standards for the industry. And I've co-authored and authored many papers that have been published by Department of Justice and NIJ on the technology. And again, I'm just glad y'all are taking time to look at the use of this technology for domestic violence. I did want to take a second to just talk about the technology, because quite often judges don't even know how the technology works. They're ordering it. They have no idea. And we do a lot of education and try to make sure that judges understand how the technology works and its limitations. When I started in this industry, a GPS ankle monitor only worked pretty much when you were outdoors. When you went in your house, it lost its signal. The participants used to have to plug in 2 times a day for 2 hours. For 4 hours of their day, they were plugged into a wall. But that's just how the technology worked. A lot has changed over the years. Modern ankle monitors last 5 to 7 days on a full charge. That means if they don't charge it today or tomorrow, we don't lose track of them. Most of the ankle monitors will last anywhere from 5 to 7 days now. We often get the question, why can't you make these things where they can't cut them off? as I said, I served on the Department of Justice NIJ committee that developed the standards for electronic monitoring. And that standard actually requires that a ankle monitor has the ability to be cut off within 1 minute or less using medical shears in case of a medical emergency. And these happen frequently throughout the United States. I used to supervise our monitoring operations center, and we would get several calls a day where somebody needed the ankle monitor removed in a hospital or an emergency room. And they would quite often call before cutting it off, and we tell them just cut it off. Don't wait. Today's modern ankle monitors also use more than just GPS to locate. They use Wi-Fi location technology like your cell phone does. They do cell phone triangulation. They also give the providers the ability to communicate with participants, which is critical, especially, back during COVID when we needed to talk to people without having to go visit them. So a lot of the modern ankle monitors can actually talk to participants, and the one they use for JSG monitoring actually talks in multiple languages, which also breaks down a language barrier, because quite often the law enforcement or court officials don't speak the language that the participant does, so they can actually send messages to the participant in multiple languages. They have sirens on them in case there's an emergency and we need to get somebody's attention or warn somebody that they're in the area. There's also other technologies that are being used to a lesser degree. You may hear about cell phone tracking. That's great for very low risk offenders, but what we're talking about, especially for domestic violence, it's not appropriate because they just leave them behind or they turn them off when they don't want to be tracked. But it is good. Cell phone tracking apps are really good for victims that want to have their location tracked and compared to an offender's location. So there are uses for the cell phone tracking app. The other technology that's been emerging is the use of watches. It's attached similar to an ankle monitor, but it's on your wrist. Problem with that is the battery life. They have not perfected that to get more than 24 hours out of a charge. And if somebody, like we've all forgot to charge our cell phones, if they forget to charge their watch at night, they're not tracked anymore. And then the next day, we don't know where they are. So that is a little bit about the technology. These GPS devices collect location data, generally 1 point a minute. If there's some kind of a violation or in an exclusion area, they can collect them up to every 15 seconds. So it's great location data in case they are someplace they're not supposed to be. That data is transmitted from the ankle monitors over the cellular network. It's encrypted and transmitted to a secure server where that data then can only be accessed by authorized users. It gives us the ability to create areas where a person must be. Like, you're familiar with somebody being on house arrest. We say we create these fences around their house and say, okay, you cannot go outside of your house during certain hours. But more importantly, in the use of this for domestic violence, we're able to create areas they're not allowed to go. And we can create multiple zones to warn us before they even get to that area, and hopefully warn the victim and potentially notify the offender and tell them that they need to go away from that area so that they don't breach a exclusion zone. So these are all preset rules, following rules set by the courts. And I think this bill helps to strengthen some of those rules. For DV uses, let's face it, we're all familiar with a protection order, a domestic violence protection order, but in reality, it's a piece of paper. And it doesn't necessarily provide any other level of security other than the courts have said you can't do something. So a typical GPS ankle monitor is used to keep somebody at a certain location. In domestic violence cases, it's used to ensure that they stay away from a certain location. it's great data if somebody does violate a protective order. It's no longer a one person's word against the others. We can clearly see where they were every minute, in some cases every 15 seconds, if they do violate a protective order. There's not a question whether the victim will call the police, because when these ankle monitors have a breach of an exclusion area, the police are notified. And there's not a question, well, will the victim call this time, or will the offender be able to talk her into not calling the police? So it's great evidence if they do breach, but more importantly, the participant knows that they're going to get caught if they go into an exclusion area. And again, it's not one person's word against the other. But it's also, we are very conscious about making sure the victim doesn't have this false sense that, oh, this ankle monitor can protect me and this is all I need to do. So every good domestic violence program, continues to reinforce, personal protective plans that the victims have to have to ensure their safety while they're wearing an ankle monitor. I know yesterday when I talked to Sarah, we talked a little bit about other states that are looking at or have passed. There are a number of states around the United States that have passed similar legislation. I think probably the one that is the strongest is in Tennessee. Anyone charged with a felony domestic violence, it's mandatory that they wear an ankle monitor when they're released. Connecticut is another big one. Connecticut has a statewide program. They've done it for a number of years, and it's been in effect long enough now. We have good data. There are a lot of great studies out there, if you take time to read them, to show the impact that ankle monitors have on domestic violence. But there's probably nobody in this room that hasn't had a family member impacted by domestic violence. And if you ever have a family member who is truly fearful of their ex-boyfriend, ex-husband, this bill, this technology helps to provide that additional layer of security, which can help them sleep at night, can make sure that it's not just me calling the police, it's the monitoring center calling the police. So I'll be glad to answer any other questions you have. I've been doing this a long time, so I'm not just looking at it from a local or a Michigan perspective. But again, thank you for taking time to do the research before just passing a bill.
Thank you, Dave. One other thing I want to address with this is, as a lot of that are involved in this arena, that, bonds companies or GPS tethering companies are in it also to make money, right? And, one of the things we discussed yesterday in putting more teeth in the bill was to actually make sure that entities are kind of like a certified entity, and that there's some sort of penalty if the GPS monitoring company doesn't report to the authorities as well. And some states have went a little crazy with penalties, in my opinion, but, some are doing it well. But, where there's actual consequences for the GPS monitoring system to not notify the authorities as well. So, like I said, and like Dave said, we had a robust conversation yesterday. I'm sure there's going to be additional conversations. But if you guys want to know domestic violence stats, I have lots of those too, actually right here as well. I printed some. But with that, we'll do questions. Rep. Breen.
Thank you, Madam Chair. And I really appreciate that you're taking your time with this to get it right, because this is a tough thing. You're trying to balance a presumption of innocence with keeping victims safe, and that is a very hard balance to strike. So my main concern right now in questions, and you may or may not have info, is implementation, particularly like the cost and availability of EMDs. Sometimes it can be $100 to $300 a month. If the cost is shifted to the defendant, just as an example, and they are ultimately found innocent, would they be able to get that money back? I'm wondering how you plan on addressing that.
Sure. So right now, these devices can be ordered right now by the courts. But what this is saying is with aggravated domestic violence, which is, as you know, a more serious offense in the domestic violence statute, that as a condition of their bond, it is ordered, right? And right now there's different mechanisms. I mean, obviously, so in particular in my county, if you are ordered under pretrial services, we have a fund for this. We did have some discussion about this with some other counties, like potentially making changes with indigent defense. But yes, I mean, at this point, the cost is on the defendant. I mean, it's kind of like a user fee is what I'm going to call it. When you're arrested for something like this, obviously it's very serious. Now, the final adjudication, that's another thing. But in the meantime, I don't see a place where they're reimbursed for that cost if it's actually ordered. And like I said, this is the very serious domestic violence situation. So that's discussion we'll have to have down the road. Further, I had that discussion with some judges as well, and district court administrators as well, because there's other counties that don't necessarily use a lot of pretrial services, or, those funds are expended already. So there's going to have to be more conversation in that.
Sarah, can I add one
Thank you,
thing
Chair
on that?
Lightner.
I mean, we've heard this argument before. In serious domestic violence cases, if there's a protective order in place, they typically will tell the offender he can no longer go back to the residence. Very similar, they have to go stay in a hotel or find another residence and pay for that cost. This is no different in my mind. They have not been found guilty, and they're being told they can't even go back to their own home. In some cases, they own that house, and they're still innocent. But these are very serious crimes. They're crimes involving an intimate partner, and this has been a nationwide discussion similar to you're bringing up about who pays for it.
Sure. And we're not naive to the fact that, it's not like you mentioned it, Dave, we're not naive to the fact that it's not going to prevent violence. I mean, if there's a will, there's a way. We all know this. However, in the unfortunate cases that Dave deals with, a lot of times this information is actually used for a murder trial, unfortunately. And, location services are really, really good now, usually within a few feet, the accuracy level. So, it's just another layer of protections, I guess, out there, and making sure there's justice at the end of the day. With that, seeing no more questions, we are going to move on. Thank you, Dave. Thanks for being here and taking the time to talk to us, and we'll be talking again soon.
Thank you.
Thank you. Okay. We have Kyle's, I can't read it. Zawicki, that's a W, from ACLU of Michigan, opposes the bill and does not wish to speak, but written testimony was submitted. And then we have Brianna Williams, representing the Vera Institute of Justice, opposes the bill, does not wish to speak. Okay, with that, we are going to go ahead and move on to Rep. DeBoyer on whistleblower protections. You have the floor.
Thank you, Madam Chair. Thank you, members. I will be very brief. This is rather simple. Bill 4781 simply makes some amendments to the current Whistleblower Protection Act that was established in 1980. It expands the ability for victims to be made whole. Additionally, at the discretion of the judge, it allows those victims to be provided potentially 3 times the amount of their back wage that would be owed to them, which in civil cases is not necessarily an unusual thing, treble damages. It also allows for the judge to rule that reasonable counsel fees, attorney fees, can be reimbursed. And additionally, it moves the current civil fine that could be levied against the individual that violates the act from a current $500 to a $2,000 fine. Perhaps, the question may be, why is this necessary? Well, number one, the $500 fine was established in 1980. And so here we are, 45 years later, it's still $500. Additionally, you may argue, why should an individual be awarded 3 times their lost wages? The truth is under the current statute, there's really nothing that a victim is afforded other than reinstatement of their job and the wages that they lost because they were out. While they have literally been a victim of poor treatment by, theoretically, their boss. Let's just use that as the generic term. So there really is no deterrent in this bill to prevent a supervisor of any fashion to think twice about having retribution against an individual that may come forward and provide information of illegal, unethical activity going on in an organization. That is the simplicity of my testimony. The bill is actually that simple. It's an amendment that makes those modifications. I would be happy to take questions. I have been approached by Rep. Edwards, who actually introduced a bill last term that addresses the Whistleblower Protection Act as well. And there are some good ideas there. So I think we'll probably have some further discussion about those ideas that maybe we can integrate into this. And they do make sense, and I do appreciate that information that has come to us. So that conversation will continue, but I'd be happy to take any questions. Chair Lightner.
Thanks, Rep. DeBoyer. Rep. Breen.
Thank you, Madam Chair. Thank you, Rep. DeBoyer. I'm really glad that you brought this forward. This is great. And I'm wondering if you are open to looking at making it even better.
I am.
So,
sure.
As an example, it's a fairly short statute of limitations.
It is.
Would you be open to expanding that or covering additional employees, such as others that come forward after the original whistleblower, or even applicants?
Potentially, sure.
So
I think that is worthy of the discussion. I do believe, and I think currently, and I'm going to memory, not flipping, I think it's a 90-day statute of limitation on it currently. And I think that there's room for discussion on that for sure.
Happy to hear that. Thank you.
You bet.
Rep. Johnson.
Thank you. Like so many new laws or amendments, the public doesn't know that let's say this passes and we improve it, and I like what you're doing. I appreciate that. I would love to encourage a way to get the word out, and I don't know if you've thought of that yet, but the public needs to feel empowered to be able to do appropriate whistleblowing, not lying, not fraudulent accusations or false allegations, but appropriate whistleblowing without the fear, and this would empower things like that. So I don't know if you've thought of that or discussed that.
Yeah, I mean, I haven't gone that far as to think about how you market this out so individuals are aware of it, but I would say that there's mechanisms by which that could be done, I would guess. And if we're fortunate enough to get to the point that occurs, I think that we could work on that for sure. Yeah.
Thanks, Representative. And, I just want to bring to the committee's attention some issues with not having whistleblower protections and the cost it is to the state. I know of some cases right now where we have state departments even that are under scrutiny and being sued now by individuals that used to be employed here. And so, it's a problem. It's also one of those things that we need to hold our state departments accountable for actions and, people being able to disclose bad behavior and, you know, make sure that they're not afraid to actually come forward and hold those people accountable, because, you know, some of those are just appointed to those positions, and, you know, we're elected, and so, you know, people have no problem coming to us and complaining about us in public and in private. So it's like, I think a lot of times some of our own people need to be held accountable and responsible. So thank you for bringing this. With that, we're going to move on. Not wishing to speak in support of bill, Mitch Albers from Michigan Association for Justice. With that, we are going to move on to voting on House Bill 4781. Or no, I'm sorry, not 4781. 4755. It's a Rep. Nancy Jenkins bill in regards to consumer protections. Rep. Bagol moves to report House Bill 4755 with recommendation. Madam Clerk, will you please call the roll?
Chair Lightner.
Yes.
Representatives Bagol.
Yes.
Wozniak.
Yes.
Harris.
Yes.
DeBoyer.
Yes.
Johnson.
Yes.
Shooty.
Yes.
Carter.
Yes.
Hope. Breen.
Aye.
Scott. Yes. Madam Chair, you have 11 yeas, 0 nays, and 0 pass. The motion prevails.
Thank you, Madam Clerk. Seeing no further business before the committee is adjourned.